We have one final myth to tackle, and it's a big one. You guys ready to get out your loud voices again? Okay. Are the organized bar and judiciary opposed to new models that can expand who can help in closing the justice gap? Okay, yell out. Myth. To help us unpack this, we couldn't have just one or two voices. We needed a whole panel of experts. To introduce and moderate our panel, please join me in welcoming to the stage a fellow Rural Justice Task Force member, a retired partner at Quarles and Brady, Fred Gantz.
Can everyone hear me okay? They used to tease me in my office that they weren't sure when there was long distance telephones whether I really needed a phone for the Madison area. Just about reach anywhere.
We've got some online folks, you may need a microphone.
Oh, okay, that's right. Yeah. Yep.
All right, shall we?
Well, good afternoon, and thank you, Rebecca, for emceeing today. We just heard Nicole speak about new categories of legal helpers that are changing what access to justice looks like at the community level. Now, to debunk the final myth of that story, we'll shift to the policy side, to the courts and bar leaders who are enacting changes to make structural changes possible. This conversation will challenge the idea that the legal profession and judiciary strongly oppose the idea of non-lawyers providing civil legal services. In fact, we're joined by three esteemed leaders who have lent their energy and national influence to broadening who can help solve legal problems. As a member of LSC's Rural Justice Task Force, an active legal aid pro bono volunteer, I hope that all of you in the physical and virtual audience also will agree that creative solutions can be done pragmatically, ethically, and with great benefit to underserved communities, in particular rural ones, where I practiced a great amount of my life. You know, people talk about traveling to such places as Miami and Los Angeles. I was a little more attuned to Neillsville, Platteville, and Wausau, the Colorado of Wisconsin. So we're fortunate to have with us Michelle Benke, President of the American Bar Association. The world's largest voluntary association of lawyers, judges, and other legal professionals. Michelle, like me, has the good judgment to call Madison home, where she is a member of Boardman Clark's business, real estate, and estate planning practice groups. And that has been an outstanding firm, long committed to legal aid in our community. The Honorable Joel Bolger, Senior Justice of the Alaska Courts System and a member of LSC's Rural Justice Task Force, is with me to my immediate right and your immediate left. Born in Iowa, Justice Bolger came to Alaska as a VISTA volunteer for Alaska Legal Services Corporation in 1978. For 30 years, he engaged in public and private practice and served as a trial judge in the rural Alaskan towns of Dillingham, Utqiagvuk, Valdez, and Kodiak. And I had the privilege to visit Valdez this summer, just for a short period before I loaded a cruise ship. Texas Supreme Court Justice Brett Busby is a seventh-generation Texan, third-generation Eagle Scout, and lifelong violinist who grew up in Amarillo and Austin. Justice Busby was appointed to the Supreme Court in 2019 and serves as the court's liaison to the Texas Access to Justice Commission. He also serves on Frontline Justice's National Leadership Council. As we begin our discussion, I'd like to share something that Justice Busby said in fall 2024 as the Supreme Court of Texas prepared to issue proposed rules allowing legal professionals and court access assistants to provide limited legal services for low-income individuals. It is unacceptable that 92% of low-income Texans are not being served by our legal profession. Their basic civil legal needs are real and serious. They include protection from domestic violence, denial of veterans' benefits, and access to housing and food. We must explore innovative structural changes like those in today's order if we are to close this gap and ensure that justice is not simply a privilege for those who can afford it, but a right guaranteed to all. So let's start with a broad view. Each of you represents a state or an institution that has taken real steps to expand who can deliver civil legal assistance. So Justice Busby, I'm going to start with you. What shifted, either in mindset or circumstances, that made your institution say yes to, or at least explore piloting these changes, particularly for rural and low-income communities?
Sure. Well, thanks, Fred, and good afternoon, everybody. It's a privilege to be here and be part of this discussion. This is a personal issue for me. My dad is a rural lawyer in a small Texas community and confronts these issues on a regular basis, and we see them all the time in our court system. And I think, as Fred mentioned, we have proposed rules that have been out for comment on licensing, not only our version of community justice workers, which we call court access assistants, but also legal paraprofessionals to do limited legal practice. And so the process that led to the order that Fred was describing, there were really several different pieces that sort of came together, I think, to galvanize people behind action here. One was just the statistics. 92% of low-income Texans and Americans not having access to basic civil legal services, I think, is just unacceptable. And I think when most legal professionals, when most people in the community who are concerned about their community hear that, they're really astonished and dismayed by that. We, of course, along with that, Texas has huge rural legal deserts, as a lot of states do. We have 254 counties, and there are some that have, you need at least 3 lawyers in a county to have a lawsuit. And a lot of our counties don't have that many, so unfortunately. And I think one thing that really helped people understand this is that it's really a basic economic problem of supply and demand. Anytime you limit the supply of a service, you're going to have unmet demand, and the cost of the service is going to go up, right? That's what they teach us in basic economics classes. And when you start to think about the problem that way, you realize that, as Nicole said, it's a problem of supply. And how can you increase the supply of available legal services? And so from there, you realize that, well, who's responsible for making decisions in this area? And it's state Supreme Courts and state legislators that are the regulators of the legal profession, and that have the capacity to do something about it. And then the final thing, I was a pro bono volunteer when I was in private practice, did a lot of legal work for free. Can't do that anymore as a judge, but am honored to be able to help in other ways. And have worked with our Legal Services Corporation grantees. In Texas, we have tremendous grantees. I've gone up several times to lobby members of Congress to talk to them about the help that Legal Services Corporation funds give to people in their communities. And it's so essential what LSC does and what our pro bono lawyers do. And even with that, there's this huge unmet need. So what do we do in addition to that? That's all very important, and we need to continue doing that and growing it. But that alone is not going to solve the problem. The grants to LSC and all the other institutions that fund civil legal services provision, and the lawyers who are stepping up to provide services for free. The need is just too great. And so when you bring all of those factors together, I think that's really what led our court and our bar to look at, what sort of innovative changes can we make here to meet the rest of the need.
Any reactions from, I've got other questions for our other panelists, but any immediate reactions?
No,
Go ahead.
I think the justice is right. It is a supply question. And I think it's also an issue of, to a certain extent, where the pieces are on the chessboard. Within the ABA, we see younger lawyers coming out. They have a significant amount of debt. I have two adult children in their 30s, so this is not a blasphemy against young people, but they want to be in vibrant communities. They want to have access to social lives, and so it does become difficult to get them to go where there might not be two other lawyers. So that issue of kind of the supply and demand, and none of us are going to mandate that they go some particular place. We can try and entice them, as the State Bar of Wisconsin is, but I do think it is a supply question.
And I know, Justice Busby, when we had talked earlier, you had pointed out that Texas is a large state, but it has rural areas where there are not law schools. So,
Yeah.
It's a struggle, and it's not just the smaller rural states. Justice Bolger, I want to get the Alaska perspective, especially having been to Alaska this past summer. Alaska's geography presents extraordinary access to justice challenges. From your perspective, how can the judiciary view non-lawyer helpers as essential partners in serving these vast regions?
Well, Fred, as Nicole told us just a few minutes ago, in Alaska, the access problems are very difficult. Most of the communities in the state do not have access to the road system at all. And also,
I didn't get to those areas.
and it's not just parts of Alaska that don't have a law school. We don't have a law school at all. Mm-hmm. So it's been natural throughout the history of the state to look for non-lawyer professionals in the communities that we want to serve to provide these services. In the 60s, just after statehood, the court system had a system of non-lawyer magistrates who provided the daily routine services, sometimes just over the kitchen table. And in the 70s, Alaska Legal Services began to have remote paralegal offices that provided legal services. It was just natural about the same time that this task force began that the Supreme Court passed a rule that allowed legal professionals to practice under the training and supervision of Alaska Legal Services Corporation. Now we have 42 locations across the state, and that's a beginning to try to solve this justice gap.
Michelle, I want to, and thank you, Justice, really appreciate that. Michelle, I want to talk about ABA's national perspective. As ABA president, you've seen states experimenting with new roles and pilot programs. How is the ABA supporting or partnering with those efforts? How might the ABA's national reach and influence help ensure quality, ethics, and consistency as states experiment with new models?
Well, the ABA has been a long-time supporter of equal justice and access to justice. Almost every state has some statement that lawyers have an obligation, whether it's mandatory or aspirational, to provide pro bono services. We go and advocate. I want to make sure you come with us when we do ABA Day so we can advocate for LSC funding. So we have that long history. But a phrase that we're using more often these days is change is like heaven. Everybody wants to go there. They just don't want to go there right now. Having the discussion about how we can solve that gap is one that we are having within the ABA. And we have a great opportunity, a great capacity for convening. And so as we have seen some of the folks that are serving on these task force, and they have proposed these things, like any good group of lawyers, we push and pull and debate and discuss and debate and discuss and debate and discuss. But ultimately,
Lawyers do that, huh?
we do. We do. It's one of our core competencies. But we did pass the resolution recognizing that using community justice workers would be a key part of solving this issue.
And that's a perfect lead-in to something that I wanted to ask Justice Bolger and/or Justice Busby, because when we were preparing for this session, Justice Bolger used the expression "community justice workers" that you just referred to, and I love that expression. So with that, I'll ask Justice Bolger and/or what approaches were most effective in building buy-in among your judicial colleagues?
Well, I think on this issue, Fred, it's important to choose approaches that do not threaten the bar or the court system. For example, approaches that focus on professionals that are supervised by a legal aid organization, approaches that involve just legal aid work. In Alaska, workers do food stamp applications, Indian Child Welfare Act cases, debt defense, domestic violence. There's no competition with practicing attorneys in those areas. And so these positions can be filled by volunteers and nonprofit employees in the communities that they served, but still under the supervision of the legal aid organization. I think that's a great first step.
Well, and one of the things that you pointed out, again, when we were preparing, is that this sometimes creates an alternative or flip side to this, is it sometimes creates an opportunity for lawyers to hire many paraprofessionals, several paraprofessionals within their office, and be able to provide legal services to individuals that they wouldn't ordinarily be able to provide. In other words, it provides an opportunity to expand their practices because these individuals are not being served by higher priced lawyers and they have problems such as debt issues and some of the other issues that we've talked about, including in the tribal areas, sometimes there are significant estate planning issues in terms of inheriting property and so forth. So it provides an avenue for expansion. I thought about this when we were talking about it. For many years, there was a lawyer in Fond du Lac whose name I forget, but he had an office where he was the only lawyer, and he had 4 paralegals working with him, and had a quite extensive legal practice for many years. Justice Busby.
Yeah, I think the point that you just made, Fred, is really, I think, a key towards getting buy-in from other judges for this type of system, and that is that the a lot of our constituents, the folks who pay the money to run the court system, the folks who elect us, we have an all-elected judiciary, so the people who elect me are not getting legal services. And that should be, we should be responsive to the needs of our constituents. And it's because, for financial and other reasons, the market has not developed in that area, and also due to the limitation of the providers, the markets have not developed to be able to provide the kinds of legal services that you just mentioned. So I think judges realizing that the members of their community are not being well served by the current structure is part of it. Also, realizing that the courts and this differs a little bit state to state, but at least in Texas, for us, the court has a constitutional responsibility to regulate the profession. And so that this really is on us in large part to convene people and figure out how are we going to solve this problem. And then also, I think one of the things that in talking with my colleagues around the state that they really appreciate, because they see this all the time, they have so many people coming into a system that's not designed, as was said earlier, not designed for people with lawyers, but without representation, but it's an adversary system. And so we as judges are not allowed to give people legal advice, and it can be very frustrating and heartbreaking at times to have people come in who have a clear need, and we're not allowed to tell them what to do under the current configuration in a lot of our courts. That's why some of the types of initiatives that were talked about earlier about how might we change the structure of some of these proceedings are very interesting in part for solving this problem. But, I think judges, and often because we can't help people, the cases take a long time and there have to be a lot of resets. This point was made earlier too, and so it takes a long time for the cases to get resolved, and the courts end up with huge dockets, and it's a problem just for getting their business done.
We need all the help we can get.
Absolutely.
And Justice Busby, you'd made a point earlier when we were preparing that I love, that I know Justice Dallett will relate to very well. Texas, like Wisconsin, as I understand it, roughly about half of our states in the nation elect our judges.
Right.
And you said you were elected to represent all Texans, not just lawyers.
Right.
I thought that was fantastic. We'll move on to our next question, having to do with building buy-in and mitigating opposition. And to some degree, we may have answered this already, but I'll ask it to Justice Busby one more time. Many states are navigating questions about how to expand who can help while maintaining quality and accountability. From your experience, what concerns have surfaced in these conversations, and what safeguards or partnerships have proven most effective in addressing them?
So I think in part, as Justice Bolger said earlier, there are, President Banky mentioned this as well, and with the resistance to change, and sometimes there's a lot of discussion and debate, which is very healthy. But I think as a profession, we're somewhat resistant to change and appreciate the way that things have been done. But we can see that it's not working. But there is some resistance to change. There's some resistance to competition. But I think, as Justice Bolger pointed out, the target of a lot of these efforts is areas where people are not being served currently. So you're not displacing current practices. Although we have had some concerns from solos and from rural practice saying, this is an area, whether it's landlord-tenant or consumer debt or probate, family law, those are the cases where we see the most unrepresented people. And there are people who have figured out a way to make an economically viable practice in those areas, and thank goodness that there are. But there are so many people out there who need those services that one of the things that we've trying to explain through this effort is that it's not really competing with those folks. We're just trying to provide enough services in those areas. And the steps that we took to do that really involved our Access to Justice Commission being a convener and bringing in judges and lawyers, Legal Services Corporation, grantees, lawyers from those programs in the state to bring ideas, and also having wonderful speakers, including some of those in this room, and we're so grateful that they came to speak with us about experiences in other states, and really getting some data on how are these programs working in other states. Arizona has been such a leader on this, and I think that helped a lot of people see that this can work. There were concerns about quality, for example. What's the quality of the service that's going to be provided? And when you just have to look at the data in Arizona, and I'll get to that a little more in a second, but the other thing that we did was bring in lawyers from the affected practice areas where we see the most unrepresented people and said, we want to work with you on this. What do you consider a paraprofessional or community justice worker competent to do if they can pass an exam in the case of a paraprofessional, or they're being trained or supervised by a lawyer in the case of a community justice worker? What would you consider, you're the expert in family law, what would you consider them competent to do? You work with paralegals all the time. If they can pass an exam, and so we got a list, and that's where we started and said, okay, well, we want to work with the bar on this, and they're the ones that know very most how, what the simple kinds of legal tasks are that these additional categories of providers would be most helpful with. So that was some of the steps that we took, and I think the safeguards that we put in place to help address some of the concerns were either testing in the case of in the case of paraprofessionals. To be able to get a limited license, you'll have to pass an exam and have some training for that. Also, supervision in the case of our court access assistants, which are our community justice worker model, and then having a robust grievance process. But again, I think Arizona has seen that you almost never have to use it, and people have been extraordinarily satisfied with the work. Lawyers have gone and checked the work and said, this is first-class work. There have been very few complaints, and so it's working well on the ground.
And could you just briefly summarize what in fact, you've talked about Arizona being a leader here. What in fact did Arizona do? I'm not sure that I totally followed that.
Yeah, they've done a lot of different things.
Okay.
In addition to what we're talking about here today, they've changed the way that the legal profession can be financed as well. And so that's another whole separate topic of conversation that we could spend a lot of time on. And you've probably heard some of that in the news recently with some accounting firms and others entering the legal sector in Arizona. But they also have a very robust paraprofessional licensing program in Arizona, and we learned a lot about that through this process.
And we're not going to talk too much about those accounting firms or that, because that's kind of another
That's a-
another area outside of our scope today. Michelle, how did you bring skeptical members and ABA leadership along in the process?
Well, first, I'd have to say I didn't do it by myself. Really, the ABA process, our House of Delegates is our policy body. It's almost 600 lawyers, and that means there are 700 opinions. But that process really does unearth the issues and the questions, and much like we've done today here, it gives us an opportunity to do some of that myth-busting and to really dig deep. One of the presenters earlier talked about, and it's one of the things that probably took a good amount of the focus, you want to provide assistance, you want to close the gap, but we are generally talking about groups of people who either don't have a voice, don't have resources, and so you don't want to give them, it's not just even two-tier system, you want to make sure that there is not harm that will befall them. Because if they weren't able to access the system and get their issues resolved in the first instance, they are not going to be able to access a system for redress. And so thinking about what the parameters ought to be, thinking about whether it's licensure, whether it's supervision, those are all of the kinds of things that we discussed and debated. And I think what you saw in our resolution, which is another really important point, is there's not one size that fits all. What works in Alaska may not work in Wisconsin, or what works in Arizona may be able to be duplicated. So recognizing that the goal of providing that greater expansion of access is the goal. How you do it in your particular community may have to be tailored to your specific community. And then outlining some of those things when you're applying your solution that you should be thinking about to make sure that you're not doing any harm. And so that's really how our resolution came. We didn't come with one solution and we said, this is the only way in which community justice workers could be employed. We really acknowledged that there were these differences and all of them could be parts of the solution wherever you might be.
Yeah, and if you take a look at the report, you're really going to see that. So like, for example, in Tennessee, church-based institutions play a major role in informing individuals about legal aid needs. I've spent a fair amount of time in Montana in recent years because my wife's sister-in-law lives there. And also, the co-chair of my working committee was Allison Paul, who's the head of Montana Legal Aid. In Montana, they have bar coasters in the bars that address the issue of do you have any legal aid, do you have any legal problems in certain areas? And I can tell you, having been in Montana, there's a lot of bars. It's, I'm saying that as a compliment, not any criticism. And so that, again, it's just there's so many different approaches that have been successful. It's very, very interesting to see. Justice Bolger, one of the driving forces, and this again is something we may have already covered, but one of the driving forces behind these changes is unmet need. The justice gap is vast everywhere and slightly more pronounced in rural communities. What initial outcomes in Alaska or other states suggest these reforms are actually improving access to justice?
Fred, part of our rule required study and reporting of the system. And since the rule was passed, Alaska Legal Services Corporation has now over 200 community justice workers. So that's one measure of success, is it worked, the recruiting part of it worked. Also, the return seems to be phenomenal. When studied, a group found a 25-to-1 return on investment for this program, in addition to the $23 million of awarded food stamp benefits to worthy recipients. There's up to $16 million of additional benefits that were returned to the community, all for kind of a small investment to bring on these workers in the communities that they serve.
Excellent. I've got a question for all of you. For states that haven't yet moved in this direction, what would you say are the essential first steps? And I will point out that I think a number of our speakers have already suggested some of them, but I'm interested in your comments.
Well, I think you're right. Start with reading the report. You don't have to start from scratch. It is often the case if one state has done a study or had a task force, then another one has to do a task force. The need is now and the need is real. So I don't know that you have to necessarily start with creating your own task force. There's a lot of information out there. The ABA has gathered a lot of that information. Other states, other folks that have talked. Start by reviewing the information that's there so that you can kind of get a jump start on what it is you want to do. Then I think, again, as many people have said, engage the stakeholders. You don't want to propose something and then find that you've got, the state bar, the local bar, whatever, standing at the door raising concerns and issues at that moment. Try to involve as many of the stakeholders as early as you can in the process. And then finally, I would say, keep track of what is actually happening when you implement. There are states that have started things. There are states that have moved away from some of the first things that they did. Just because it didn't work out exactly as you had envisioned in the first instance doesn't mean it's a failure. It gives you an opportunity to kind of move along the continuum, make some tweaks or major changes, but you have to kind of track what actually happened so that you know whether you're solving for X and how you can continue to improve it.
Excellent. Anything to add?
I just wanted to add, I really think our clients are the place to start. By that, I mean our legal aid clients, because that is the place where the courts need the greatest assistance, and that is the place where the lawyers have the most minimal objections to this kind of a program.
Excellent point.
And-
Justice Busby?
And having them tell their stories is extraordinarily effective too, to the people that, as Michelle said, I think she laid out the plan beautifully. But once you've got all those people convened, they need to know, like, how does this really make an impact on people, so that they get buy-in of, this is something that really does make a difference, and that people are entitled to, and that will not make a difference for them, it'll make a difference for the court system. And for the state. So I think that's, telling those stories, making it personal, bringing it home to people makes a huge difference as well.
Sure.
Yeah, I thought it was fantastic. One of our speakers go ahead, Michelle.
No.
Okay. One of our speakers made the point that you just start speaking with other people. That's a first step, and some experiences that I've had recently. I play tennis with a Dane County Circuit Court judge, and we don't talk about his exact thinking on a certain case. I read about it in the newspaper, but he will. It's again an opportunity to meet people and start. Gee, what could we be doing to improve access to justice? It can start with one conversation, and then I think you can also learn a tremendous amount from actually doing the work. So I had one client that I was recently working on a pardon application with, and you're trying to pick a location to meet at, and we made several appointments at my office, gave him directions how to get it. He wouldn't show. That kind of intimidated him. So ultimately, we decided on a Starbucks in Sun Prairie. Now, if you've ever been to Sun Prairie, it's a growing community. There are 5 Starbucks. Look, a little difficult to figure out which one he wanted to be at, but we got there. And it's a whole matter of going out and meeting the people, meeting the clients, so.
Well, and just to pick up on that point, somebody referenced the free legal answers, which the ABA supports,
Right.
and the state has. And I participated just generally because that was part of how I was solving my pro bono obligation, but that has given me and continues to give me a firsthand look at the kinds of issues. And we had the myth. People don't walk up and say, "My issue is I have a complicated
Right.
probate." Right? It's, "Hey, my sister has done X," or whatever. And to be able to just even figure out, is this a legal issue or is this an interpersonal family dynamic issue? Those are the real things that are happening, and anything that we can do to kind of help people sift and winnow is really key, because the sooner you get to the problem, the better the outcome is.
Well, thank you all. I'm going to offer a reflection to summarize the key takeaway from the panel. We've heard that meaningful reform depends on partnership between courts, the bar, legal aid organizations, and the communities they serve. After our upcoming break, the program's going to pivot from theory and policy to practice to the people doing this work in the places where life happens. And we've already heard a lot of fantastic personal stories today. I love the one about the 85-year-old gentleman and the case that got won. I had, it's like another example. I had a case in Montello many years ago where I showed up and the opposing lawyer wasn't there, so the clerk of court called him and said to me, "Oh yeah, he's just getting out of the bathtub. He'll be here shortly. He's a little late."
Hard
So-
to get that picture out of your mind.
Yeah, if you met him, that's a very apt comment, Justice. It's another example of you just got to go to where the people are and serve them. And I hope we haven't taken the thunder away from the speakers that are going to be coming up, because I know we've got a lot of additional great stories to hear. So thank you all so much, and we'll take a break.
Thank you, Fred.
Thank you so much.